Hi, good morning, everyone. My name is Lisa Spiegel, and I'm presenting today with my colleague, Lauren Parrish.
Good morning.
Our presentation today is entitled Managing Privileging and Resource Allocation Amid COVID-19. I just want to start with some housekeeping notes. We remind everyone that you have been placed into the webinar in muted mode. We have a significant number of participants today, so we do ask that you leave your lines on mute so all of our colleagues can hear the presentation clearly as we go through the webinar this morning. Due to the number of participants we have today and the amount of material we intend to cover in this short time frame, we will not be holding a Q&A session at the end of this session. However, you're always welcome to send in your questions by using our contact information on the slides. So they appear for you now, they'll appear for you at the end. And we'll be pleased to respond to any questions you may have regarding this presentation or related issues. This presentation is provided as an information service and is a summary of current legal issues. This information is not meant as a legal opinion, and viewers are cautioned not to act on information provided in this publication without seeking specific legal advice with respect to their unique circumstances. So with that, we will start. And I do want to thank you for joining. The topics that we'll be exploring today address the rapidly changing landscape we find ourselves in Ontario, particularly those in the healthcare sector. We'll be looking at an overview of emergency orders and directives, both what are now historical. Each new day there's something new, so we're dealing with some historical and the new emergency orders and directives. We will be talking about privileging issues. We'll then shift to the issue of redeploying staff. We'll turn to litigation, looking at the lessons that have been learned through the SARS crisis in Ontario, as well as emerging issues and some hot off the press cases that have already made its way into the courts in respect of COVID-19. And finally, we'll turn to risk management considerations. So we find ourselves in what I'm calling a rapidly changing landscape. Since the onset of this healthcare crisis in Ontario, orders and directives have come at the healthcare sector at rapid fire speed, difficult to keep up at times with the pace. On April 20th, the government put out a news release advising that the community spread had likely peaked. And actually yesterday, Doug Ford released safety guidelines for employers as Ontario prepares for a gradual reopening. Our collective consciousness changed in respect of COVID-19 on March 11th when the WHO declared the coronavirus a global pandemic. But going back to the beginning in Ontario and in our anticipation for the surge, seeing what other countries and states had also been anticipating or in fact seen, the Ministry of Health asked and then subsequently directed that hospitals ramp down their elective and other non-emergent clinical activity. More recently, Christine Elliott looked forward and noted the province will begin scheduling these elective procedures again as soon as the province is able. This has meant that while certain privileged health professionals were and are ramping up, others have had to significantly ramp down, both in and outside of hospitals. The need for physicians has varied depending on specialization and practice. And this has obviously resulted in scheduling issues, which may have implications for professional staff privileges. It may require, in some cases, the need to onboard new physicians and require the expeditious granting of privileges when needed. Resource allocations may also impact the privileging of existing health professionals.
As I'm sure you all know, on March 17th, the province of Ontario declared a state of emergency in order to respond to the spread of COVID-19. Following that declaration, a number of temporary emergency orders were enacted, and these were enacted under a piece of legislation called the Emergency Management and Civil Protection Act. Many of these orders impact hospital staffing, scheduling, and resource allocation. The information is changing rapidly as new orders are being enacted or amended frequently. We're going to highlight some of the orders at a high level over the next few slides, and we'll refer to some of them in more detail throughout the presentation to discuss the impacts on healthcare facilities and professionals. So on the screen, you'll see some of the emergency orders that are in place so far, a number of them relating to the health industry. These orders first beginning on April 9th, permitting construction of temporary health or residential facilities. On April 16th, we see new orders permitting LHINs to request that frontline workers be redeployed to other care settings. And we also see an order permitting ambulance services to hire and assign students who have not yet graduated. Moving towards the mid part of April, we see orders restricting both long-term care home and retirement home employees from working in more than one healthcare setting. But really one of the first orders, which was enacted on March 21st, is Regulation 7420. And this really did provide a broad new mandate for health service providers. Health service providers under this order is defined pursuant to the Connecting Care Act, which is a broad definition that includes hospitals, psychiatric facilities, and long-term care homes, among other institutions. They're all under the scope of this order, which requires and authorizes health service providers to take any reasonably necessary measures with respect to work deployment and staffing to respond to, prevent, and alleviate the outbreak of COVID-19. So it's broadly worded, but it does explicitly permit providers to employ additional temporary contractors for this purpose. And that's where we get into the employment and onboarding of additional privileged physicians. Do note that this order was amended just last week to provide some specific guidance with respect to long-term care. And Lisa's going to expand on that amendment later on in the presentation.
In addition to the orders, there have been a number of directives. As you know, Section 77.7 of the Health Protection and Promotion Act authorizes the Chief Medical Officer of Health to issue directives to healthcare providers where there exists or there may exist an immediate risk to the health of persons anywhere in Ontario. And indeed, the Chief Medical Officer has done so, issuing a variety of directives that have requirements and implications for various parts of the health sector and for a variety of health professionals. So we're going to discuss these directives, some in more detail than others, as relevant to this discussion. The first directive was issued on March 12th. Day after the WHO declared this a global pandemic, and it dealt with precautions for healthcare providers and entities with respect to COVID-19. It addressed things like droplet and contact precautions for routine care, as well as airborne precautions for care provided on patients with suspected or confirmed COVID-19. Importantly, it directed healthcare providers and entities to review and adopt the updated infection prevention and control recommendations for use of personal protective equipment with suspected or confirmed cases of COVID-19.
The second directive of 5, which are now published, was released on March 19th. This is directed to healthcare providers. And as I'm sure you all know, it directs healthcare providers to cease or reduce all non-essential and elective services until further notice. This was following the request from the ministry, and it's now in formal directive form. There are specific exceptions set out in the directive. Non-essential or elective services can still be provided if the circumstances are time sensitive, if they're required to avert or avoid negative patient outcomes, or similarly, if they're required to avert or avoid a situation that would have a direct impact on patient safety. The directive provides some guidance on how to make decisions with respect to ramping down elective services. And I know many of you have been grappling with these decisions for quite some time already since this directive came into force. They're difficult decisions and they require contextual analysis. The overarching guidance from the directive is that decision-making process should be fair to all patients, and to influence and guide the quote-unquote ramp down decisions. The directive focuses on 4 principles, which are set out on your slide. First, decisions should be proportionate to the real or anticipated risk on a limited ability to provide services. Decisions should attempt to limit harm to patients wherever possible. With respect to equity, all patients in the same patient category should be treated and affected the same way. And the general reciprocity principle invites additional considerations into your decision making, and the directive specifically highlights the fact that consideration should be given to the fact that certain patients and patient populations will be particularly burdened as a result of canceling non-essential services. As I noted, these are difficult decisions. There's not going to be a black and white framework. It's going to depend on the facts of each specific situation, but we certainly recommend that institutions document their analysis with respect to any ramp down decisions, including the rationale and the considerations leading to such a decision. And this document will then be available if issues or questions arise in the future.
And just some of those questions, which we will get to later, may in fact pertain to privileging issues. But moving on to the third directive, which this directive issued on March 30th is a directive specific to long-term care homes. And it's the subject of a case that came out quite recently that we'll explore in some detail towards the end of our presentation. This directive prescribes specific requirements for long-term care homes to immediately implement, and suggested as well that retirement homes should take reasonable steps to follow them as well. The directive included implementing active screening for COVID-19 of all staff and essential visitors except for emergency first responders. It includes active screening for all residents, for new admissions and for readmissions. And it stated its expectations that long-term care homes are expected to follow the first directive I spoke about earlier in respect of PPE. It also stated that wherever possible, employers and employees should work together to limit the number of work locations. And that's subsequently been revised, as we'll get into when we talk about the redeployment of work. There's lots more to this directive. I'm not going to attempt to capture it all. Much of it's on the screen, and much of it's probably something you're aware of as well. Again, I won't say too much about this directive for this presentation. We wanted to highlight it, but this directive number 4 is specific to ambulance and paramedic services.
Directive 5 is specifically directed to hospitals. Some of this directive is prescriptive, and some of it puts a specific onus on the hospital to act in certain ways and to have certain things in place. The directive requires hospitals to implement specific precautions and procedures with respect to point of care risk assessments, contact and droplet precautions, and access to, as well as training with respect to personal protective equipment. So as you can see on the screen, at a minimum, contact and droplet precautions, which include gloves, face shields, gowns, and masks, must be used by workers for all interactions with suspected, presumed, or confirmed COVID patients. Similarly, any workers who are within 2 meters of a suspected, presumed, or confirmed case must have access to the N95 respirator or an approved equivalent. If based on a point of care risk assessment, a worker determines that certain health and safety measures may be required to provide care, this directive states that the hospital must provide appropriate access, and that may include access to the N95 respirator. Importantly, this directive puts an onus on the hospital to do ongoing risk assessments of health and safety control measures, including the supply of PPE. And this really is important. Hospitals must make best efforts to conduct these assessments on an ongoing basis. And again, it's very important to document the assessments and the analysis be informed the assessment. This is an important risk management tool as the documentation may well need to be relied on at a later date in order to explain or potentially defend the decisions that were made.
So at the outset and throughout, we've spoken about scheduling changes that have taken place as a result of COVID-19 and a need to both ramp up the provision of certain services in some specialties and in some areas of the hospital and reduce them in others. In addition to addressing COVID-19, which has taken the vast majority, if not all of the time of most health organizations, for hospitals, there's also an appreciation that at the same time, there may have been an requirement to consider annual renewals for physician privileges, which would be dealt with by the MAC, or in addition to consider potentially new applications for privileges. And generally speaking, the Public Hospitals Act and the hospital's bylaws will provide the hospital with tools to manage these circumstances. So, for example, in light of the need to ramp up, there are going to be opportunities, I'm sure there have been opportunities and will continue to be, where new professional staff may quickly need to be granted privileges. The notion of temporary privileges, which would be set out in hospitals' bylaws and should be looked at specific to your own bylaws, is a truncated process. And the reason it's truncated and it dispenses with the typical onerous obligation and requirement to effectively credential your physicians is that temporary privileges are generally granted for a set period of time to fill a specific and urgent need, which is where we're at now in these circumstances where you may need, again, to onboard someone quickly. At the end of the day, the timeframes and the specifics of temporary privileges will be set out in your bylaws, and you should check them to ensure compliance with your particular bylaws. I want to speak about the deferral of the MAC's recommendation to the board and what may be required or considered as you go forward. The Public Hospitals Act provides that within 60 days of receipt of an application for an appointment of privileges or a reapplication, the MAC must consider and make a recommendation to the board. It acknowledges, however, the Act acknowledges that there may be times when this 60-day timeframe simply can't be achieved for one reason or another. In those cases, it's possible to delay that 60-day requirement. But in order to do so in accordance with the Public Hospitals Act, the MAC, the Medical Advisory Committee, must give notice in writing to the applicant and to the board that it needs more time to make its recommendations, and it must give a reason. So the timing of a hospital's annual meeting or an MAC's annual meeting to consider renewals may come or have come during this COVID crisis, where the MAC either can't meet or suddenly needs to consider COVID-related issues as a priority and wants to put these issues of renewal on the back burner. In such cases, a formal notice of deferral may be warranted. Again, you want to check that is coming straight from the Public Hospitals Act, but you'll want to seek counsel on that as to whether it's required depending on the timing. When a physician is told by the MAC that their privileges will not be considered within the 60-day time frame to make a recommendation to the board, those privileges do remain uninterrupted. So there's no negative implication to the physician in putting off the MAC coming together to consider and make recommendations on renewal. On the issue of scheduling changes, I've already said that the hospitals will have had to and will continue to make significant changes to scheduling. So we've already seen a ramp down, we're going to see a ramp up, and there's going to be lots of people that have not received services, patients that have not received services, they're going to be coming to the hospital, lots of physicians that have not been able to practice in the areas that they've typically been practicing at hospitals. And so there's going to be a significant amount of scheduling changes as you've already seen. Depending on why and how those changes are implemented, there will be privileging considerations. And so Lauren's going to speak specifically to the issue of privileging now.
So as Lisa just noted, hospitals have and they will continue to be required to make scheduling changes for physicians and other privileged health professionals as a result of ramp down and ramp up, as a result of bringing on new health professionals. And these scheduling changes may affect the privileges of existing professional staff. In order to determine if privileges will be, or have been affected, we first need to know what are privileges. And this proves actually to be a bit more difficult of a question than it might seem. There's no statutory definition for the term privileges, which means that that term is not defined in any piece of legislation. No law, no legislation sets out what privileges are and what they should include. There's a body of judge-made case law that has offered some insight into the subject. One of the first main cases is an unreported decision, which is on the screen. That's Dittmer v. the Board of Directors of Parkwood Hospital. And here, the board stated that privileges are, quote, a bundle of rights that includes some degree of access to material and human resources at the hospital, which is obviously quite a broad definition. and certainly can change depending on the specific circumstances. When attempting to determine the scope of a particular physician's privileges, the first place to look is the letter from the hospital board which grants those privileges. So does this letter set out specifics with respect to the scope of that physician's practice at the hospital, specific procedures, specific patient volumes, specific workload? It often will not, and in that case, the case law has set out some considerations. So the Rosenheck case, which is on the screen, is a Court of Appeal case, which states that privileges include the resources which are typically employed in the practice in which that physician engages, and include the resources to which the physician has historically had access to in his practice at the hospital. Similarly, in the Vargava decision, the Health Professions Appeal and Review Board stated that privileges may also be determined with reference to the historical volume of patients seen and the historical income reported by a physician. So why is it important to determine whether there has been an alteration of privileges? The content of one's privileges matters because Section 41 of the Public Hospitals Act states that where a member of the medical staff of a hospital considers himself or herself aggrieved by a decision which, quote, substantially alters his or her hospital privileges, that member is entitled to written reasons for the decision if a request is received, as well as a hearing before the Health Professions Appeal and Review Board, again, if a written request is received. So a substantial alteration of privileges triggers rights for the physician at issue under the Public Hospitals Act, and that can lead to litigation. It's important to remember that not every decision to reallocate resources or to change scheduling will amount to a substantial alteration of privileges. Whether a specific decision does amount to a substantial alteration will be determined through a contextual analysis on the specific facts of the case. In conducting such an analysis, the courts will consider the factors that we previously discussed to determine what privileges the physician had before the decision and what privileges they have after the decision. So for example, does the decision result in the physician no longer having access to certain resources that they typically had access to or that they did have access to before? Does the decision result in a lower patient volume or a lower reported income? But it's important to remember that even if a hospital decision does substantially alter a physician's privileges, that decision may still be justified and it may still be defensible. The case law demonstrates that courts will show deference to decisions made by hospitals with respect to resource allocation, given the complexity of making such decisions, if that decision is fair and reasonable. From a risk management perspective, hospitals will want to be able to demonstrate that any resource allocation or scheduling decisions that are resulting from COVID-19 are in fact fair and reasonable. And therefore, even if the decision does substantially alter privileges, it will put you in a more defensible position. The case law indicates that to demonstrate that a decision is fair and reasonable, there's a number of things that the courts will want to see in place. The decision to reallocate work or resources should be applied uniformly, such that it affects all physicians in a particular group. So for example, a decision that affects all the physicians in a particular department. A decision that singles out one physician or unduly impacts or affects one decision will be much less likely to be viewed as fair by the courts. The decision should not be arbitrary, and it shouldn't be based on some inherent bias against the physician who is affected by it or some bias on the part of the decision maker. And any decision to reallocate work or resources must be rationally connected to the goal of managing COVID-19. So there needs to be that nexus between the steps that are taken and the decision made and how that decision will actually help to stop the spread or help to manage COVID. Again, the decision-making process and the rationale should be documented and documented carefully. This will demonstrate the considerations that were taken into account when the decision was made, and this may well become an important part of a defense if there is a challenge with respect to privileges, and we will talk about a few cases later in the presentation where there was such a challenge.
Before I move to the issue of redeploying staff, I want to speak about one more aspect that may of scheduling changes and other physician-related issues that may impact privileging, and that is scope of practice issues. So the CPSO, the College of Physicians and Surgeons of Ontario, has a policy that I believe was put together after the SARS experience in Ontario, which addresses the issues of physicians practicing outside their scope. Typically, each physician's certificate of registration contains a term that they can only practice in the areas of medicine which they are educated and experienced. I say typically, all certificates of registration start that way. Sometimes physicians will have other restrictions or conditions on their certificate, but the default position is that certificates of registration include the requirement that one can only practice in the areas of medicine in which they're educated and experienced. There's obvious reasons for that. But the college policy, which is triggered in a public emergency, allows physicians to deviate from this requirement. And in doing so, they must use their professional judgment and work with their colleagues to determine appropriate medical care. Importantly, it's not just, here's COVID, we can practice outside our scope. There are conditions that must be followed. Physicians can only practice outside their scope in accordance with this policy in an emergency setting, which we are in, if urgent medical care is needed, if another physician is unavailable, and if a patient is not put at an otherwise greater risk. So it's a risk analysis and a fact-based analysis to see whether it applies. Hospitals supporting physicians practicing outside their scope. In fact, some hospitals may need or have needed physicians to do that, depending on the volume of cases coming in and the type of physicians they have privileged. But hospitals supporting physicians practicing outside their scope in these circumstances must be clear about the parameters, both what that scope looks like and the time frame for deviating from the typical principle, which is you don't practice outside your scope, and they must be clear about the rationale for why why this change to a physician's scope is happening. And it ultimately may require adjustments to privileges. Again, that's going to be a case-by-case assessment, and I would seek advice on that point if it becomes applicable. So I now want to turn to the issue of redeploying staff, which is shifting gears. And we're going to turn to it both in respect of contracted service providers as set out in the Home Care Community Services Act and with respect to long-term care homes. So on April 16th, actually, if you can just go back, Lauren. Yeah, thanks. On April 16th, an emergency order was issued stating that LHINs may request that contract service provider organizations safely reassign frontline staff as may be needed. It also said that service providers may accept the request and deploy employees to provide services as requested by the LHIN, and also that the employee of the contracted service provider organization, which by the way includes those providing homemaking services and personal support services, is not required to agree to provide the requested service. Now, I want to take some time to speak about the issue of redeploying hospital staff to long-term care homes. On April 17th, the ministry asked hospital CEOs to voluntarily identify staffing resources that were able to provide long-term care homes with infection prevention and control assistance, medication assistance, and nursing and personal support worker staffing. Now, the impetus for this, sorry if you can go back, Lauren. This is the remote working putting on a presentation. So the impetus for this was the ministry noted that high levels of staff absenteeism caused by illness and mental distress have exacerbated the situation in long-term care homes, such that additional trained staff are urgently required to ensure the safety of residents and staff. As I said, days later, this request turned into an amendment. No, you can switch, thank you. And the amendment gave the authorization for defined healthcare service providers, including hospitals, to provide this assistance to long-term care homes. Now, importantly, when deploying staff to long-term care homes, staff remain staff of the health service provider or hospital. They are not employed, but rather seconded to the long-term care home. Next one. As a result of the order, hospitals can set staff schedules and assign duties for their staff within long-term care homes while assuring the staff that they remain employees of the hospital with all rights guaranteed to them under their collective agreements. It also enables hospitals to deploy infection prevention and control to ensure the safety of all workers.
So turning now to some of the case law and starting kind of with some of the past case law and the lessons learned from the SARS outbreak. Some case law came out of the SARS outbreak that sheds light on how similar situations involving COVID may be decided by the courts. Generally speaking, the SARS cases indicate that healthcare workers cannot refuse to work in circumstances where the risk of working is one that's inherent or a normal condition of their work, or where the refusal to work would directly endanger the life, health, or safety of another person. However, healthcare workers may be justified when looking back on the SARS cases in refusing to treat patients diagnosed with an infectious disease if the workers do not have adequate access to personal protective equipment. And we're going to highlight two specific cases that came from SARS that are applicable in the time of COVID. The first case that's on your screen is a professional discipline case involving the College of Nurses Discipline Committee, and it highlights the obligations on regulated health professionals in a pandemic. This case relates to a nurse who worked at two different hospitals during the time of the SARS outbreak. One of those hospitals had a SARS outbreak, and as a result, she was required to quarantine for 10 days. This nurse did not quarantine and instead reported to work at the second hospital. She was brought to the discipline committee of the College of Nurses, and the committee found that she had engaged in acts of professional misconduct by failing to quarantine. Specifically, she had failed to maintain the standards of practice of the profession and had engaged in conduct that would be regarded by the members of the profession to be disgraceful, dishonorable, and unprofessional. In this case, the nurse's license was suspended for 12 weeks. She received an oral reprimand, and she was required to take courses on both ethics and on infectious diseases. So, demonstrating that the colleges will take the safety requirements in light of infectious diseases, including quarantining, quite seriously. The next case that's on your screen is the Abramson case, and this relates to what I discussed earlier with respect to decisions regarding resource allocation that may substantially alter a physician's privileges and the specific justification for those decisions at an institutional level. In this case, Dr. Abramson worked at the North York General Hospital. In 2001, the hospital had plans to expand the level of diagnostic testing that was conducted at its Branson site. And Dr. Abramson was told that as a result of that expansion, there was an expectation that his level of diagnostic testing work at that site would increase accordingly. Fortunately, the hospital's planned growth for the Branson site was not successful, and this was partly due to the SARS outbreak and the reluctance for patients to undergo in-hospital testing post-SARS. As a result, Dr. Abramson repeatedly expressed concerns about what he viewed to be an inadequate allocation of diagnostic testing work at the Branson site. The hospital and Dr. Abramson entered into lengthy negotiations about his allocation of diagnostic testing work, and ultimately the hospital's MAC decided that they did not want to proceed with further negotiations, and they weren't willing to reconsider his allocation of diagnostic testing work. The MAC advised Dr. Abramson that their decision not to continue with any negotiations, and that their decision with respect to any changes to the quantity of his diagnostic testing work was due to, quote, a variety of high-level macro variables that were not specific to him. Dr. Abramson took the decision of the MAC not to continue negotiations with him, and he appealed that decision to the Health Professions Appeal and Review Board, and he considered that decision to have the effect of causing a substantial alteration to his privileges because he felt that he was not receiving the appropriate allocation of diagnostic testing work. However, the Health Professions Appeal and Review Board dismissed his appeal, and There's a number of reasons for that, but part of the reason for the dismissal was the board's opinion that you can see on the screen in the quote, that the reason for the decreasing level of diagnostic testing work at the Branson site was multifaceted, and it was not entirely based upon any one intentional decision of the hospital's hierarchy to alter Dr. Abramson's privileges. Particularly, the board cited the changing nature of in-hospital testing following the SARS outbreak as a factor that contributed to the decreased work quantity generally, and that general decrease had an effect on Dr. Abramson. So here, in the Abramson case, we see the board showing deference to the hospital's decision-making process, even though Dr. Abramson's quantity of work was affected, because the decision was thought through, it was determined to be reasonable, it was determined not to be made to single out Dr. Abramson, but to be made on a department level, at the level of diagnostic testing for the entire site. And it was influenced by external factors that were outside of the hospital's control, including a decrease in overall workload following the SARS outbreak. Turning to case law that's coming out of the current pandemic, on March 15th, a notice of profession was issued by the Chief Justice of the Superior Court that suspended most regular operations of the court, save for some urgent and emergency matters, and those include matters related specifically to COVID-19. As a result of that carve-out, there is case law emerging already with respect to COVID that we will highlight a few relevant cases now. The first case that's on the screen is Sprague v. Ontario, and the Divisional Court released its decision in this case on April 17th. In this case, the plaintiff, Mr. Sprague, sought a judicial review of the North York General Hospital's decision to implement a restricted visitor policy. So this is a type of policy that we're seeing in a lot of healthcare institutions, very severely limiting visitor contact with patients in an attempt to control the spread of COVID. And in this case, the new policy meant that Mr. Sprague could not visit his father, who was a patient at the hospital, and who Mr. Sprague also served as substitute decision maker. So there are a number of issues active in this case, including substitute decision making, the legitimacy of the policy, and in fact, whether the policy violated rights under the Charter of Rights and Freedoms. The court dismissed Mr. Sprague's case, and it held that the hospital's decision to change the visitor policy was actually not subject to judicial review by the court. However, it went on, even after making that decision, to comment specifically on charter rights. And the court held that the visitor policy did not violate Section 7, 12, or 15 rights. Section 7 being the right to life, liberty, and security of the person. Section 12 being the right to be free of cruel and unusual punishment. And Section 15 being equality rights. The court found that this policy was onside. It did not violate any of those rights in the circumstances. And as you can see in the quote on the screen, the divisional court stated that Mr. Sprague's critiques of the visitor policy were, quote, really an attempt to engage the court in a reweighing of the complex and often difficult factors, considerations, and choices that must be evaluated by a hospital administration during a pandemic. They held that this was not the court's role because significant deference must be afforded to the hospital in the circumstances. The Sprague case demonstrates that the courts will in fact give deference and significant deference to hospital decisions that are made in good faith to manage the risk of COVID-19. And coming out of this case, hospitals should remember that when making decisions to change policies in order to respond to COVID, they should ensure that the amended policies are thought through, that they're compliant with emergency orders and directives, and that they're in line with the best available clinical evidence, which was also an issue raised in the case. Patient safety and stopping the spread of COVID must be the central rationale for policy decisions, and there needs to be a nexus between how the changes to the policy align with the directives and the clinical evidence and how they're actually expected to connect to reducing the spread.
So next we want to turn to a case I referenced I'd be speaking about earlier on, and that's the case of Eatonville. That seems like a lifetime ago in the time of COVID, where time moves slowly, but it was really just last week, heard on April 22nd. This case is an injunction brought by ONA on behalf of nurses at 4 long-term care homes. And these 4 long-term care homes had experienced a COVID-19 outbreak, with both resident and staff having contracted the virus, and with at least, unfortunately, 54 residents having died. ONA asked the court to issue an order seeking homes to refrain from breaching directives and to take any and all reasonable precautionary measures to ensure nursing staff receive health and safety protections as per the directives. And these directives pertain to supply and use of PPEs and cohorting. Specifically, applicants were asked that the long-term care home provide them with appropriate access to PPEs and to implement required administrative controls for long-term care homes, including allowing nurses to make their PPE decisions on an ongoing basis at the point of care. Resident long-term care homes argued that the issue was about scarcity of resources, and that the directive takes into account not only what nurses determine to be necessary, but what the long-term care home says is appropriate and reasonable in the circumstances, having regard to issues in relation to the global scarcity of resources. Now, the public health experts in this case, of which there were many that testified, gave varying evidence as to the efficacy of PPEs and the transmission of the virus. And in light of there being conflicting opinion, including about whether the virus was airborne or not, and the, the degree of scientific evidence to determine issues like that, the court noted that, quote, the only real conclusion I can draw from these battle of experts is that the evidence regarding the transmission of the COVID-19 virus continues to evolve. And the court emphasized that in light of this evolution, the importance of OSHA provisions to take every precaution reasonable to protect employees, which is called the precautionary principle, they emphasized this precautionary principle. Next, if you can turn to the next slide. And so the court also cited what it characterized as the important recommendation coming out of SARS, which is that the precautionary principle is to be put into action in order to prevent unnecessary illness and death, even when it cannot be established with scientific certainty that there is a causal link between activity and harm. So the entire point is to take precautions against the as yet unknown. Now, the court stated, while all personnel working in the field are advised to be reasonable and to take account of long-term and short-term needs in making their assessments, it is the health and safety questions faced by nurses and other health professionals on the spot that is given priority in the directive. It's a very important point. And it found that the balance of convenience, which is one of the 3 parts of a test when determining whether an injunction should issue, favors those measures that give primacy to the health and safety of medical personnel and those that they treat. The court stated that respondents were ordered to provide nurses working in their respective facilities with access to fitted N95 facial respirators and other appropriate PPE when assessed by a nurse at point of care to be appropriate and required, as set out in Directive Number 5 issued by CMOH. And I read what that directive was earlier. We discussed it. The respondents were further ordered to implement administrative controls such as isolating and cohorting of residents and staff during the COVID crisis, as set out in Directives 3 and 5, issued by the Chief Medical Officer of Health. And so it'll be interesting to watch as that case progresses. That's the first stage of it, being the injunction.
We are seeing some jumping off points from the arguments and the parties in this case. Just last week, a class action lawsuit was filed with the Superior Court. It named 6 long-term care homes, including Eatonville, as defendants, and all 6 have deaths that are alleged to have occurred due to COVID-based claims that the homes failed to protect residents. So this case is not yet certified, but with the court, class action lawsuits need to specifically be granted approval for certification by the court. That has not yet happened, but if it does, it will raise interesting and novel questions, including what is the expected standard of care during a state of emergency or global pandemic? What is the responsibility of homes in this type of climate, and how can they appropriately respond? So it'll be certainly an interesting one to watch as it progresses through the court system. However, and that will likely take some time, but it will be interesting nonetheless.
So we've got a pretty dense slide here, having considered a lot of dense information. I'm not going to purport to talk to you about all the risk management considerations. Some have been discussed throughout, but I do want to highlight the following when it comes to these issues. First of all, of course, it's important to review the skills, expertise, and competence of new professional staff members being onboarded to your organization. Also recognizing some flexibility in terms of scope of practice. It will be important with new CPSO licensure that has been that they have been granting to review and confirm that appropriate licensure is in fact in place for anyone that you are any physician that you are onboarding. You'll want to identify the rules and scope of practice and when a deviation may be warranted. Of course, anytime you deviate from the norm, as Lauren said a couple of times, you ought to document the rationale for doing that so you can look back on it at a later date if you are required to do so. It'll be important, of course, to ensure necessary training and supervision, including as it relates to PPE. There will be an understanding, you'll be required to clarify and understand applicable policies and procedures. You'll want to, as we said a number of times, document risk assessments. When it comes to appropriate documentation, you're going to want to make sure that you're implementing appropriate documentation, including waivers, confidentiality terms, secondment agreements, collaboration agreements, and others applicable to the circumstances, particularly when you're talking about issues involving redeployment of staff. Various template documents have been circulated, definitely a useful starting point, but you want to make sure that those documents are tailored to accurately reflect the arrangement and protect your particular interests, including issues of indemnity. You're going to want to, of course, confirm insurance coverage when you're dealing with these changes to personnel. And of course, when in doubt, we do urge you to contact legal counsel to inquire about interpretation of various directives and orders so that you can be on side throughout this rapidly changing time of COVID.
That wraps things up for us. Lisa and I want to thank you very much for joining the session today. We know it's a lot of content and the content is changing, it seems, almost every minute. We are certainly available if you have any questions following the presentation or any questions that arise throughout this changing and an evolving period of time. Please feel free to contact us. Our contact information is on the screen, and we're happy to field any questions that you may have. And we thank you very much for attending today.
Thank you. Bye-bye.